So good evening, everybody, and welcome to the civil seminar for tonight. I'm very, very pleased to introduce Luminita Olteanu, who is teaches at LSE, intellectual property law, and she's also a qualified lawyer and has practiced for 8 years in various fields of law as well as intellectual property. And today she's going to talk about something which is really interesting and up to date, I think, which is the relationship between brands, trademarks, and dilution, and how do we juggle these three different ideas. So thank you. Over to you.
Thank you, Jennifer. Hello, everyone. My name is Luminita Olteanu, and I'm very happy to be here with you today. And I would like to take this opportunity to thank Jennifer, to thank Fanning, to thank Sipil for the kind invitation. My plan for today was to discuss the main points that I'm trying to raise in my paper, which is called Seeing Trademark Reputation with Fresh Eyes, Lessons from the Consumer-Based Brand Equity Models. And in doing so, I would like to focus on 4 main points, which I have here on this slide. Basically, I would like to say a few words about the background of this paper and what motivated me to seek alternative ways to see trademark reputation with fresh eyes, and in the context of the test for trademark dilution infringement. Next, I intend to provide a brief overview of the consumer-based brand equity model, which in my opinion might be of relevance for the test for dilution infringement. Here I will explain how certain brand dimensions which make up the consumer-based brand equity model can map onto the various iterations of trademark reputation, which we know from the case law of the CGEU. Then I will move on to briefly discuss some consumer research insights, which might be of relevance when we are assessing the likelihood of blurring, tarnishment, and pre-riding. And finally, I am going to try to explain how my proposal to reconceptualize the test for dilution infringement in accordance with these marketing theories can be integrated in the current test for dilution. Now, this should take about 45 minutes, after which I'm very much looking forward to your feedback, to your questions, and to your criticism, of course, both online and in person. So basically, this paper is part of a broader research project, actually my PhD, which investigated the normative justifications for dilution protection, and it also sought to elicit new ways of understanding how trademarks with reputation can be blurred, tarnished, or unfairly exploited. And as part of that broader research project, I was also, one of the questions that I was trying to answer is whether the current dilution test is clear enough so that those concerned with the rules on trademark dilution will be able with a relative accuracy calculate the legal consequences of their actions, but also the outcome of legal proceedings. And looking at the test for dilution infringement that we know from the case law of the CGEU, it will be conspicuous that the due cause requirement is missing from this diagram, but that was on purpose because that is not part of my presentation, and I was not necessarily looking at that part of the dilution test. What I was interested in, however, was to see how the Court of Justice and the General Court of the CGEU actually looks at the reputation requirement, not only when it's making an assessment of the type of trademarks that qualify for this broader type of trademark protection, but also how reputation is assessed for the purposes of the link, and also how the reputation of the trademark is assessed by the General Court when the likelihood of blurring, tarnishment, and free riding has to be made. So what I did was to look at the case law of the General Court basically, I was looking at appeals against board of decisions of the EU IPO. As I was telling you, I focused basically on the role played by the reputation requirement and these other factors that we know that need to be taken into account. For example, these are the Intel factors that have been laid down by the Court of Justice with respect to the link. And obviously the other factors that stem from the L'Oréal and Belure, and obviously the General Motors criteria relating to reputation. And in the following slides, I will provide some examples from the case law of the General Court, which I personally found a little bit strange in terms of how the assessment of the link was made, and also in relation to the assumptions which the court has made in relation to how consumers perceive trademarks, how they engage with trademarks, and what actually impacts their purchasing decision. So the first case that I want to refer to in this first part of the presentation, it's a case from 2015. Here we had the senior trademark, which had been registered for goods in class 25, clothing. It was a German trademark. The court found that it had reputation, so there was no problem that, you know, the trademark, the senior trademark doesn't have reputation. And obviously it opposed the registration by this other tobacco company, which was trying to register the Mustang trademark, obviously with the figurative element as well for tobacco products. And here, with respect to the link, the court basically said that the nature of the goods in question is so different that there isn't actually a risk that the junior sign would somehow evoke the senior trademark. And even if in this case, the court actually acknowledged that certain companies such as Davidoff can sometimes branch out. They do not only sell goods, sell clothes, but they also branch out into like coffee and tobacco products as well. But in this case, somehow the court considered that despite the high degree of similarity of the signs, despite the different nature of the goods, a link is not possible. Now, I cannot complain, and I do not feel sorry for the fate of the reputed trademark, but I found it interesting to contrast the decision in Mustang with a more recent decision from 2020 in the Novomatic case. Here we had the senior trademark, which had reputation for goods in class 32. It was registered for lager beers. It had a high degree of reputation in Belgium. And obviously it opposed the registration by Novomatic of the identical word mark for goods in class 28. And in this case, the court also recognized that the goods and services in question actually had a different nature, but somehow, because in establishments where beer was offered, oftentimes you would also find some sort of machine or equipment for playing games of chance, there is somehow a risk for consumers to kind of associate the junior sign with the senior trademark. Again, I am not necessarily convinced, or if we look in parallel at the Mustang case and the Novomatic case, I personally am not convinced by this kind of reasoning. Now, moving forward with respect to other equally bizarre assumptions about certain consumer decision and consumer understanding of trademarks, I don't know if you all remember the Beatles case. Apple Corp here opposed the registration by UQBV of the word mark Beetle for wheelchairs. So this company here, UQBV, wanted to register, trademark the word mark Beetle for wheelchairs and devices for people who had some sort of mobility issues. And obviously Apple Corp is the owner of the famous The Beatles trademark, registered for entertainment services, among other things. And obviously the trademarks were similar. Apple Corp managed to demonstrate that their trademark had a huge reputation. There was no problem about the link. But here, in terms of the assessment of free riding, how and why would UQ derive some sort of unfair advantage from the use of the Beetle trademark for wheelchairs? to me, this sounds problematic, not only from a trademark point of view. So here the court said that the very positive image portrayed by the Beatles trademark could benefit the goods, wheelchairs, since the relevant public, on account specifically of the handicap in question, would be particularly attracted by the very positive image of freedom, youth, and mobility associated with the earlier trademarks. And then again, the court somehow made an assumption about the age of the people who would be using wheelchairs and so on and so forth. So again, I find this a little bit bizarre. Similar assumptions about what informs the consumer's decision-making process we can find in the Farmeco case. Here, with respect to the risk of free riding, the court said that the trademark Botumax, which would have been registered for detergents, because of the similarity with the Botox trademark, would somehow give rise to an unfair advantage, because consumers might think that Botumax cleans surfaces in the same way as Botox removes wrinkles. Now, I have not used Botox yet. I am not able to kind of confirm or infirm the findings of the court here. But again, it looks a little bit bizarre to make these kind of assumptions about what consumers might think and why they could be somehow persuaded to buy certain goods and services. Finally, I'm going to go back to the Mustang case. And here, although the courts found that there was no link, so as a matter of principle, the analysis should have stopped there. The court somehow went further and kind of investigated whether a risk of damage to the reputation of the senior trademark used for clothing would be possible or not. And in this case, interestingly, there was evidence that the general public that was concerned with clothing in Germany had a rather a not so positive image about smoking. And however, the court said, you know what, we cannot assume that the trademark will lose its attractiveness just because of the association with tobacco, which again, this goes a little bit against what we know about tarnishment and the textbook examples of when tarnishment can occur or not. Now, after looking at all these cases and some other cases where the Court of Justice has applied logical deductions in order to assess whether there is a risk of infringement or not, I reached the conclusion that no, the current test for dilution infringement doesn't necessarily provide an adequate level of predictability of the cases. Now, if we are to look at the causes, which is something that I do not directly address in my paper, but I address in the broader research project I was telling you about, which investigated the normative justifications for dilution, I concluded that one of the reasons why we do not have an adequate level of predictability is because we don't have clear normative justifications for dilution protection at the EU level. Another factor that kind of contributes to this kind of lack of predictability, in my opinion, is the quantitative nature of the General Motors criteria. So we know from General Motors that the degree of knowledge of the trademark, which is actually its reputation, should be measured with it as a matter of principle. I mean, this is this doesn't mean that other criteria cannot be used, but as a matter of principle, we should use market share, amounts invested in advertising, the duration of use, the intensity of use, and so on and so forth. These criteria, having a quantitative nature, tell us little about what the actual image or consumer perception of the brand is. Now, again, proof of actual dilution is not mandatory, as we all know. I can understand why proof of actual dilution is not mandatory. In most of the cases, in opposition cases, the junior trademark has not been put into circulation, and obviously there is no evidence of how consumers would kind of engage with that trademark or the effects of that trademark. So that kind of makes sense to a certain extent. But also we don't have a test for tarnishment or free riding, at least not a satisfactory one, such as the one in the case of blurring, where we at least know that a change in or a risk of change in the consumer's behavior is necessary for the purposes of trademark infringement by blurring. Also, and the final one, which it's basically a consequence of a lack of actual proof of dilution, is these are assumptions, how I call them, about consumer decision making. And some of these assumptions that have been made in the practice of the General Court, I will try to kind of dispute with the research that I have done for this paper. So basically, my proposal would be to kind of apply the test for dilution infringement in a way that is informed by marketplace realities in terms of how consumers engage with brands, use of qualitative criteria and metrics for evaluating trademark reputation, and obviously making assumptions about consumers' decision-making process, but assumptions that are somehow informed by consumer research and some more scientific ways of determining what consumers think and what counts for their buying decision. And in relation to my first proposal to assess and measure trademark reputation in a manner informed by marketplace realities, I suggest that the marketing literature on consumer-based brand equity can provide us with a very good starting point in that direction. And just to say a few words about the consumer-based brand equity model, whose main proponents are famous marketers Kevin Lane Keller and David Aker. Basically, they suggest that a brand's success can be directly attributed to consumers' attitudes towards the brand. Why? Among other things, because the process of branding and the creation of brand dimension means creating mental structures for consumers, which will help them structure the information that they have about goods and services. And obviously, this will help them in the decision-making process, and it will also kind of create some sort of value for the brand owner. And here on this slide, I have listed several brand dimensions, which are components of the consumer-based brand equity model, which map onto the various iterations of trademark reputation as we know them from General Motors, Intel, and L'Oreal. And in the following slides, I will try to explain the kinder nature of these brand dimensions and the way in which the branding literature kind of understands the relationship between them. So the first brand dimension that I would like to refer to refers to brand awareness. Now, if we were to think about the closest legal concept that we have to brand awareness, it would be the definition that we have for reputation from General Motors. In that case, the court said that the mark's reputation is a certain degree of knowledge of the earlier mark among the public, because otherwise it is not possible for consumers to kind of establish a mental link between the earlier sign and the junior mark. However, we have no sort of, the court has not distinguished between the various types of knowledge that are required in relation to that earlier mark. But if we look at the branding literature and CBBE model, we will notice that brand awareness is somehow, it's a mix of various components, including brand recognition. Basically, what brand recognition tells us is whether consumers have been somehow exposed to that earlier mark or not, which is something different from brand recall, where consumers are able to retrieve from memory some other sort of association with that trademark, including whether they know what is the commercial origin of the goods and products. And here there is some sort of hierarchy in terms of which one counts more, which one counts less, and for what purposes. And somehow what I found interesting about this brand awareness kind of dimension is that the branding literature kind of documented the fact that certain goods and services have higher levels of brand depth, and other goods and services have higher levels of brand awareness breadth. What does that mean? Certain goods, because they are encountered in a variety of consumption situations, they will normally trigger higher levels of awareness of breadth. And to my mind, using this kind of insights in the assessment of the link would help us have a less random kind of assessment of when a link is possible in the minds of the consumers, when a junior sign will be actually able to evoke an earlier trademark or not. Also, the branding literature that I have consulted for the purposes of this paper kind of distinguishes between brands consisting of logos and brands consisting of words. Here we have again a hierarchy in terms of which ones have higher degrees of recognition, which ones engender higher degrees of brand recall. Again, I found it interesting, I found it important, and I find that this kind of distinction is not made by trademark law, and if it would be made, it would make a difference in terms of how we assess the link. Now, we have to move on to the next one, trademark distinctiveness, because I'm going to talk about 7 brand dimensions, and I won't have time to discuss them in too much detail. The next one I would like to address is the concept of brand distinctiveness. Now, again, these are kindred concepts. What we know about trademark distinctiveness from the L'Oréal decision is that it's defined as the identity of the trademark, the hold upon the public mind, which basically makes consumers immediately associate that specific trademark with the origin of the goods and services. Obviously, the brand distinctiveness component tells us the same thing about the brand who has distinctive qualities that allow for the easy and automatic identification will have this brand dimension. Now, again, an interesting thing about brand distinctiveness is that it's not brand distinctiveness that actually creates value for consumer, is this other brand dimension called brand differentiation. Now, a lot of brands can have associations that consumer like, but they will be preferred to, or they will be perceived as better than other brands only if they possess unique brand association. So this conventional wisdom that we have from trademark law that the trademark will be blurred, the distinctiveness of the trademark will be somehow damaged because another trademark appears on the market, then the trademark is no longer unique, doesn't necessarily work in the same way as this kind of branding models tell us. What matters is for those kind of brand associations to be unique in themselves, because we have plenty of examples of identical trademarks to a certain extent, or at least sharing a high degree of similarity, which are perfectly fine on the market. They are not diluted, consumers recognize them, and so on and so forth. So again, when we would assess how the distinctiveness of the trademark is going to be somehow impacted by a junior use, I think this idea of finding out what are the unique brand associations that the senior trademark has and how that is somehow put in danger by the junior sign would be an interesting exercise to do. The next brand dimension that I would like to refer to is called brand image. Now we know that the image of the trademark is the actual element of the trademark that risks being tarnished or taken an unfair advantage of. And as I was saying in the beginning of this presentation, the General Motors criteria are quite quantitative and do not necessarily allow for a more qualitative evaluation of the trademark image. And again, another point that has not been distinguished in the case law is this difference between the actual brand image and brand identity, which they do not necessarily overlap. So this concept of brand image, according to the marketing literature, refers to the image of the brand as perceived by consumers, whereas this idea of brand identity only reflects the way in which the brand owner wishes their brand to be perceived. Now, this is an important distinction because, as I was telling you, sometimes what the trademark owner wants for their trademark will not necessarily result into practice. And here I have used the example of McDonald's. Obviously, their brand identity, as you can see here, on their website message, quality ingredients. I'm not necessarily sure if we all have this kind of positive associations when we think about food from McDonald's. But obviously, this would have some implications in terms of the dilution infringement test, because if there are some sort of negative associations already in place, irrespective of the degree of awareness of the trademark, maybe there is no actual possibility to kind of negatively influence the image of the trademark as this image is perceived by consumers. So this is what I found interesting. And another point which I find interesting about brand image is that that positive image will only matter to the consumer's decision-making process to the extent that they rely on that specific image when they are purchasing goods and services, at least according to the marketing and branding literature. And Keller was giving here an example in relation to a brand that sells itself as speedy and efficient. Obviously, this is a positive image that a trademark can have, but to a certain extent, the consumer will be enticed by that only if they are subject to time constraints. Someone who is not subject to time constraints will not really care about speedy and efficient goods and services. Now, to a certain extent, I think that this is what the court was trying to do in the Farmeco case that I have briefly discussed in the beginning of this presentation, when I'm saying that consumers will believe that the detergent is going to remove the wrinkles, to remove stains in the same way as Botox removes wrinkles. So I think that to a certain extent, the court was trying to kind of explain that, this can be used in a different scenario as well, this kind of message of removing wrinkles. But to my mind, it's a little bit far-fetched to kind of compare removing wrinkles with removing stains. And as I will explain a little bit later in my presentation, for this kind of purchases like chemicals, consumers have increased perceived transaction risks. And this comes with its own consequences, as we will see in a second. So these would be the things that I would like to kind of pinpoint about the differentiation that the marketing literature makes between brand image and brand identity. And I think we in trademark law, we have been engaging more with this concept of trademark identity, what the trademark owner wants its trademark to stand for, and less emphasis has been put on the actual consumer perception of a specific trademark in dilution cases. I'm going to move on to the next brand dimension that maps onto the definition of the trademark's power of attraction. If you will remember, in the L'Oreal case, the court said that, well, the power of attraction of the trademark is going to be damaged or unfairly exploited by junior users. And this is how tarnishment and free riding occur. However, we do not have a definition of the power of attraction per se. And also we don't have any metrics to kind of try to gauge the levels of power of attraction that risk being somehow impaired by a junior user. So I looked at the branding and marketing literature. I found this brand dimension called brand attractiveness, which would measure the brand's ability to attract customers. And obviously this can be measured empirically by asking this sort of questions. But I also found, and I think this one is closer to what the Court of Justice wanted to say with this power of attraction, the brand purchase intention, actually consumers' willingness to purchase the brand. And again, we have the marketing literature tells us how we can measure this, obviously by asking consumers about it. No enigma there. But what I found interesting about this brand purchase intention and how we can predict if someone is actually willing to buy that specific trademark refers to this idea of past sales. Now, if we think about the General Motors criteria, we think about market share, we think the volumes of sales, and to a certain extent, we kind of conceptualize them as predictive of future sales as well. However, here, Keller points out that in order to kind of increase the degree of accuracy of predicting if consumers are going to sell that consumers are going to purchase that in the future as well, we also need to have some sort of correspondence between these four kind of factors. So a consumer should be asked, when are you trying to purchase that good, in what context, for whom, and so on and so forth. So we have to have a degree of correspondence to kind of increase the accuracy of the predictive model. So this would be all about the power of attraction. Now, the final brand dimension that I'm going to refer to today refers to brand esteem. And this one, I think, is the kindred concept of what the court considers as the trademark's prestige. again, this concept of trademark prestige has been used by the Court of Justice in L'Oréal in order to explain how free riding occurs. Again, we don't have a definition of the prestige. I looked at the dictionary definition of prestige, and to my mind, it was very similar to the definition of brand esteem, which is a measure of how highly regarded a brand is and how well it delivers on its promise. Again, the marketing literature provides us with some interesting ways of measuring brand esteem, which to my mind are more accurate than the General Motors criteria. I will keep saying that ad nauseam tonight. I hope you won't be bothered by that. But also, again, another interesting thing about this brand esteem kind of dimension and its relationship with the other dimensions that we have discussed so far. So apparently, the brand esteem level will not always be proportional to the brand knowledge. Marketing literature tells us that in relation to old brands, and we have here MTV, some of you might actually remember MTV from years back, has a high level of knowledge among consumers, but a very low degree of esteem. Now, it is the same with Camel, which is a brand for tobacco products, has quite significant levels of brand knowledge, but lower levels of brand esteem. Red Bull, this one was a surprise for me, has increased levels of knowledge and not so high levels of esteem. These evaluations are made by the brand asset evaluator model. They are allegedly one of the world's largest leading empirical study of brands. It's online, you can all Google it and basically search for the name of a trademark and you will get this kind of, for free, this kind of analysis. So to my mind, this interesting relationship that the marketing literature kind of highlights between brand knowledge and brand esteem kind of goes, it's in stark contrast with this conventional wisdom that we have from General Motors that the stronger the trademark's reputation, the stronger the distinctiveness, the easier it will be for us to accept that that damage has been caused to it. Well, okay, we can have high degree of knowledge, but if consumers don't actually hold that particular trademark in high regard, why do we kind of have these assumptions? Why do we operate with these assumptions, with these blanket assumptions that the easier, the higher the strength of the mark, the higher the level of reputation, the easier it will be to accept that harm has been caused. So to my mind, these kind of insights kind of contradict a little bit what we know from the case law about trademark sweet reputation and the likelihood of blurring, tarnishment, and free riding. I'm not saying that in all cases the court is making bizarre assumptions. I'm just saying that sometimes bizarre assumptions kind of permeate the legal reasoning of the court. And to conclude, the way I would see all these things kind of integrated in the current test for dilution infringement, I would see more emphasis being placed on this idea of brand recall and recognition and its relationship to the consumer's decision-making process at the second stage of the analysis. Again, if we are thinking about blurring, I would be inclined to put more emphasis on this component of brand differentiations and understanding which are actually the unique brand attributes of a specific trademark so that we can then make logical assumptions about the risk of blurring, tarnishment, about the risk of blurring. And in terms of if we reach this stage, almost this final stage, depending on the type of harm claimed, if we are thinking about tarnishment, then we would want to place more emphasis on the concept of brand image, purchase intention, esteem, or attractiveness, similar for free riding. And again, if we are only thinking about blurring, more emphasis on brand differentiation and how they could impact the consumer decision-making process on a case-by-case basis. So it's not something that, reinventing the wheel or anything. It's just mapping on various dimensions of the CBBE model on the current test for dilution infringement. Now, I was saying in the beginning of this presentation that it's not only this idea of not having qualitative measures for trademark reputation that I find problematic, and I think it's a factor in the lack of an adequate level of predictability, but it's also bizarre assumptions. And these bizarre assumptions that I keep talking about sometimes are contradicted by research from the consumer decision-making process. And I will just refer to three such insights. One of them is the level of perceived risks in transaction, which makes consumers sometimes engage in more information search and be less prone to believe the promotional message of a specific marketer. Then I'm going to refer to the difference between goods and services in terms of how consumers look for information about them when they are deciding to purchase goods or services. And I'm going to give some examples of cognitive biases impacting consumers' decision-making. And in relation to this final one, I'm not really sure how to integrate it in the test for dilution infringement. However, I think we need to think about this sort of things, and we will get there in a second. But before that, I want to say a few words about consumer decision-making. The branding literature defines the consumer decision-making process as a problem-solving kind of exercise. The rational consumer wants to purchase goods and services, then they're going to go through these 5 stages here. First, we think about recognizing a need, then we engage in information search about the goods and products, the goods and services, then we are evaluating alternatives, we take the decision, we proceed, and then we go to a post-purchase evaluation. Now, what's important to note here is that the degree of involvement in each of these stages is going to kind of vary depending on some factors. And one of the factors which influences the degree of involvement is the perceived risk in transactions. And I was looking at various consumer research theories, and I have decided to show you this diagram made by Solomon and others, where they identify 5 categories of perceived risks in transactions. So when consumers are engaging into purchases that engage some sort of a monetary risk, and here we define the risk as a person's subjective judgment about the likelihood of a negative occurrence happening to them as a consequence of that purchase, they will somehow engage in greater information searches, and reliance on sources of information about the goods and services coming from the actual marketer is lower. So in general, they would tend to kind of ask for information from a specialist if we are talking about monetary risks, if we are investing, if we are buying a house. This is how consumers kind of take this kind of decisions to make purchases for goods that would trigger some sort of perceived transaction risks. And here, if we look at this one, the functional risks and how consumers kind of make this decision to buy certain goods, we can contrast it with the decision in Beatles, where the purchase of wheelchairs kind of entails some functional risks or even some physical risks. And then we tend to think, well, would the consumer of a wheelchair actually want to buy a wheelchair just because the name of that wheelchair resembles the name of a very famous brand? I don't think so. So this is how we would kind of apply the knowledge that we have from this kind of perceived transaction risks categories to the dilution test. Now, to a certain extent, the fact that consumers, depending on the goods and services that they are trying to purchase, consumers have different degrees of attention has been recognized by the Court of Justice. And if we look at the test for consumer confusion, we already know that, you know, for pharmaceuticals, for financial kind of goods and services, the court presumes that the consumer will pay more attention. But personally, I have not found that in dilution cases as well. We generally don't tend to make assumptions about the degree of attention of the consumer based upon some of the perceived transaction risks. So this would be the first insight from the consumer research decision-making literature that I would like to discuss. The second one is the difference between goods and services in terms of consumers, again, information search practices. And here we have some characteristics or differences between goods and services. Of course, when you are trying to purchase a service, you cannot look at the packaging because the service doesn't come like wrapped into some sort of packaging. It's very difficult to kind of examine it. And obviously, the information search practices in which a consumer engages are different from the practices in which they engage when they are purchasing goods. And again, the actual implication or consequence would be, from the point of view of trademark law and trademark law dilution, would be that consumers of services are a little bit more circumspect. And this would also mean that in certain cases, they are less prone to be persuaded by the promotional message of a senior trademark, and also would be less inclined to buy specific services just because they are sold under a trademark that merely is associated with the famous trademark. Now, again, I think this is somehow related to the perceived risk, and this is just another category of transactions that would kind of generate consumers engaging in greater information searches. Now, finally, and as I was saying, I'm not completely sure about this one and how we can actually integrate it in the test for dilution infringement, and what exactly would be the implication of integrating it, refers to cognitive biases, those mental shortcuts that kind of influence our purchasing decision. When we were talking about perceived risk in transaction, and we are looking at those very nicely lined up stages of the purchasing decision, we were obviously thinking about a rational consumer that takes their time, goes through all the phases before making a rational decision about what to buy. But we have to recognize the fact that that's not always, that's not everybody. And obviously, when we are engaging in habitual decision-making, there are some other factors that could influence our decision to purchase. And in this kind of situations, we might be more prone to the promotional message or not. And again, I think here we are talking about something more nuanced, and I'm not exactly sure how it could actually be implemented in the test for dilution infringement. So here I think that it would be like a matter of a case-by-case analysis to see exactly. And again, this would be very difficult to kind of implement in the test when we are talking about oppositions, when the junior sign has not been put on the market yet. I'm not necessarily sure if we have enough evidence to kind of map or rely on such biases to understand how consumers were impacted or not by a junior sign or a senior sign. So I think the actual usefulness of relying on knowledge about cognitive biases would be limited to cases where the junior user has actually been put on the market. Now, again, just to conclude on everything that I have said so far, this consumer research decision-making insights, I think, could be integrated in the current test for dilution infringement here, where we already know that the nature of the goods and services is one of the factors that we have to take into consideration when we are assessing the likelihood of dilution. We have to look at the relevant public. And here my suggestion would be, first of all, to see whether the junior sign is seeking registration for goods or for services. If we are thinking about goods, obviously we have to, the degree of circumspection of the average consumer will depend on the nature of goods. However, if we are dealing with services, then we have an average consumer more circumspect. I'm sorry for the small font. There was a lot of information that I was trying to put in this diagram, but I'm happy to share my slides after this presentation. Now, with respect to perceived risks, I think, again, they would also could be integrated here. We are making assumptions about the relevant public and about the ways in which their degree of attention might vary depending on the purchases in which they engage. And I think that's it, and that's 45 minutes. And thank you very much for your attention.